If you have recently deposited $10,000 into your bank account, or if you are contemplating transferring that sum of money, this 2026 update warrants your immediate attention. A mounting wave of concern has emerged among Canadian retirees who fear that a single substantial deposit could instantly position them under scrutiny from the Canada Revenue Agency. Numerous seniors across the country harbor anxiety that routine banking transactions might precipitate audits, financial penalties, or comprehensive benefit reviews. This report examines what constitutes fact, what represents misunderstanding, and what information you genuinely require to safeguard your retirement income. The paramount point demands immediate clarification. A $10,000 deposit does not constitute an illegal transaction. It does not automatically become taxable. Furthermore, it does not mechanically trigger an investigation by the Canada Revenue Agency. However, such a deposit can establish a reporting trail within the financial system, and this distinction marks precisely where widespread confusion originates among the Canadian public. Under federal legislation, financial institutions operating within Canada bear a mandatory obligation to report specific transactions to the Financial Transactions and Reports Analysis Centre of Canada, commonly referenced by the acronym FINTRAC. When any individual executes a single cash deposit amounting to $10,000 or greater, the banking institution must submit documentation classified as a large cash transaction report. This documentation transmits directly to FINTRAC, rather than proceeding immediately to the Canada Revenue Agency. The fundamental architecture of this reporting system targets money laundering operations and severe financial crimes, not the punishment of retirees who legitimately manage their personal funds. Nevertheless, intelligence gathered by FINTRAC maintains the capacity for distribution to law enforcement bodies and, under particular circumstances, to the Canada Revenue Agency when reasonable suspicion exists regarding tax evasion or additional financial violations. This mechanism generates the sensationalized headlines that proliferate across media platforms. The proposition that one deposit instantaneously designates an individual for tax complications sounds genuinely alarming to ordinary citizens. The authentic situation, however, reflects considerably more measured responses from regulatory authorities. The Canada Revenue Agency concentrates its enforcement priorities not upon the deposit transaction itself, but upon whether individuals have accurately reported their taxable income. A deposit fundamentally differs from income in regulatory terms. Numerous deposits qualify as entirely non-taxable under Canadian law. Consider the scenario where an individual sells a personal vehicle and subsequently deposits the proceeds. That transaction generally does not constitute taxable income. If someone withdraws funds from their existing savings account and redeposits those same funds at another institution, no income materializes. When a family member provides a genuine monetary gift, Canadian law imposes no gift tax whatsoever. The recipient bears no tax obligation on received gifts under current legislation. The question remains why seniors experience such pronounced worry regarding these matters. The Canada Revenue Agency deploys sophisticated data matching systems that cross-reference information derived from multiple channels, encompassing tax information slips, investment income documentation, pension disbursements, and comprehensive third-party reporting. When an individual reports modest income, perhaps consisting solely of Canada Pension Plan benefits, old age security payments, and a limited pension, yet substantial unexplained amounts suddenly materialize within their bank accounts bearing characteristics resembling income, that discrepancy can prompt inquiries during routine compliance reviews. A review operates distinctly from a formal audit in the Canadian tax system. Frequently, the Canada Revenue Agency simply dispatches correspondence requesting clarification regarding specific transactions. The agency may request supporting documentation explaining a particular deposit. When an individual can demonstrate that funds originated from the disposition of a personal asset, a matured guaranteed investment certificate, a transfer between accounts under their own ownership, or a documented family gift, the matter typically resolves without any penalty assessment. Difficulties emerge not from isolated $10,000 deposits, but from the inability to substantiate the origin of funds. The burden of proof in Canadian tax matters frequently rests upon the taxpayer. When the Canada Revenue Agency inquires about the source of money and the individual possesses no records, no receipts, and no written agreements, the process becomes substantially more stressful and complicated than circumstances require. Another domain generating significant concern involves structured deposits, a practice that carries serious legal implications. Some individuals harbor the belief that depositing $9,000 on one occasion and another $9,000 during the following week permits them to circumvent reporting requirements entirely. The deliberate fragmentation of cash deposits to evade the $10,000 reporting threshold constitutes an activity known as structuring. Under anti-money laundering statutes, structuring itself qualifies as suspicious conduct warranting investigation. Financial institutions train their personnel to identify patterns that appear engineered to avoid mandatory reporting. When individuals possess legitimate funds, maintaining documentation and depositing normally proves significantly safer than attempting to circumvent a report that functions merely as routine compliance procedure. Electronic transfers warrant separate examination within this discussion. Many retirees receive electronic fund transfers from their children or grandchildren intended to assist with living expenses. These transfers, even when recurring regularly, do not automatically qualify as taxable income under Canadian law. The Canada Revenue Agency examines the fundamental nature of each payment. Does it constitute a gift? Does it represent repayment of a previously extended loan? Or does it function as compensation for services rendered or rental income received? Context matters profoundly in these determinations. When an adult child transmits $1,500 monthly to assist a parent with grocery purchases or property tax payments, that arrangement typically qualifies as a non-taxable gift. However, maintaining a simple written notation stating that transfers constitute family support rather than payment for work or services represents prudent practice. Foreign funds constitute another subject enveloped in considerable confusion among Canadian residents. Receiving money from international sources does not automatically trigger tax obligations. Canada levies taxes on residents based upon worldwide income, but a gift received from a non-resident relative generally creates no tax liability for the recipient. However, ownership of specified foreign property with a total cost amount exceeding $100,000 potentially necessitates filing Form T-1135 to disclose those assets to Canadian authorities. This reporting obligation applies to ownership of foreign investments or property rather than merely receiving a singular gift from overseas. Failure to submit required foreign asset disclosures can precipitate substantial penalties, underscoring the importance of distinguishing between receiving money and maintaining ownership of foreign income-producing property. The relationship between deposits and government benefits requires careful examination. Many seniors receive income-tested benefits, including the Guaranteed Income Supplement. Eligibility for this supplement derives from reported income during the preceding tax year. A substantial deposit that does not qualify as income will not affect Guaranteed Income Supplement eligibility, provided proper categorization occurs and no erroneous reporting as taxable income takes place. However, mistakenly reporting a non-taxable amount as income or experiencing a reassessment by the Canada Revenue Agency that incorporates additional income could diminish or entirely eliminate Guaranteed Income Supplement payments and potentially generate an overpayment requiring repayment. Old age security similarly faces exposure to the recovery tax, widely referenced as the clawback, when net income surpasses the annual threshold established by federal authorities. Once again, net income constitutes the determining factor rather than deposit amounts. Transferring personal savings does not elevate net income. However, unreported taxable income creates precisely this consequence. The urgency surrounding this topic in 2026 stems from the Canada Revenue Agency's continued expansion of digital compliance infrastructure. Banks, investment platforms, and additional financial institutions furnish electronic reporting directly to the agency. Greater automation and more extensive cross-referencing now characterize the compliance landscape than ever previously existed in Canadian tax administration. This evolution does not signify that seniors face targeting for ordinary financial activity. It indicates that discrepancies between reported income and financial activity now achieve detection with greater efficiency. Individuals operating small cash-based enterprises during retirement, encompassing handyman services, home baking operations, or seasonal yard maintenance work, who deposit significant cash without corresponding income reporting face potential reassessment. Those who rent basement suites and receive cash rent payments without declaring that income create deposit patterns that generate mismatches in agency systems. In these circumstances, the $10,000 threshold bears no relevance whatsoever. The fundamental issue concerns unreported income. Practical considerations merit attention for anyone contemplating substantial deposits. When planning to deposit $10,000 or more in cash, the essential question concerns the origin of those funds. Does documentation exist in the form of a bill of sale? Can a withdrawal slip from another account substantiate the transfer? Does written confirmation of a gift exist? These documents warrant retention alongside tax records. The need to produce them may never arise, but their availability renders any review process straightforward should circumstances require explanation. Account consolidation, interinstitutional fund transfers, or guaranteed investment certificate liquidation all warrant retention of statements demonstrating the source of funds. Electronic transfers between accounts under common ownership create traceable records that generally present minimal explanation challenges. Greater transparency in financial history correlates directly with reduced stress during any review process. Accurate and timely annual tax return filing proves wise even when income remains modest. Filing ensures correct benefit calculations and eliminates potential surprises during subsequent years. Uncertainty regarding the taxability of particular amounts warrants consultation with a qualified Canadian tax professional. A single hour of professional advice can prevent months of subsequent anxiety. Inquiries frequently arise regarding whether the Canada Revenue Agency maintains continuous visibility into personal bank balances. The agency does not possess automatic, real-time access to individual bank accounts. However, during formal audits or official reviews, the agency can request bank statements from individuals. Refusal to comply triggers the agency's legal authority to obtain information directly from financial institutions. These powers represent long-standing features of Canadian tax law rather than recent innovations. The transformation involves the efficiency with which digital reporting and data analysis now operate. A perception exists that enforcement activities have intensified in recent years. Certain domains, particularly those involving the underground economy, cryptocurrency transactions, and digital platform income, have indeed witnessed enforcement expansion. However, retirees subsisting on fixed pensions and managing savings responsibly find that routine banking activity does not automatically create jeopardy within the compliance system. Fear-based messaging frequently omits this crucial nuance from public discourse. Such messaging implies that ordinary seniors face covert monitoring and punishment for everyday transactions. The authentic situation reveals compliance systems engineered to detect patterns consistent with financial crime or tax evasion, rather than to penalize lawful financial behavior. Proactive measures invariably surpass reactive responses in effectiveness. Establishing a simple personal system proves valuable. Maintaining a folder, whether physical or digital, containing records of substantial transactions provides essential protection. Receipt of significant family gifts warrants drafting a brief letter documenting the date, amount, and gift status with explicit notation that no repayment expectation exists. Extending loans to relatives and subsequently receiving repayment requires retention of both the original loan documentation and repayment records. Clarity systematically eliminates ambiguity from financial records. Receiving correspondence from the Canada Revenue Agency regarding a deposit should not precipitate panic. Careful reading of the communication typically reveals specific and limited scope in the request. Response within the stipulated deadline remains essential. Providing copies rather than original documentation protects personal records. Situations involving substantial amounts or complexity merit consideration of professional representation. Penalties typically attach to unreported income, gross negligence, or failure to submit required forms under Canadian tax law. A properly explained deposit does not automatically generate fines measured in thousands of dollars. Interest and penalties accumulate when income remains omitted or when required disclosures suffer repeated neglect over extended periods. The $10,000 figure possesses considerable psychological impact because it appears to represent a trigger threshold, In operational reality, it functions as a reporting threshold under anti-money laundering regulations. It does not constitute a tax threshold. It does not transform deposits into taxable income. It merely establishes a record subject to review when additional risk factors present themselves. As 2026 progresses, the most effective protection available to Canadian seniors combines knowledge with comprehensive documentation. Understanding the distinction between income and deposits proves fundamental. Comprehending reporting requirements applicable to foreign property ownership matters significantly. Maintaining records of substantial transactions demonstrates prudent planning. Filing complete and accurate tax returns annually completes the protective framework. Decades of savings accumulation and contributions to the Canada Pension Plan and Old Age Security System deserve protection. Safeguarding these assets requires organization and awareness rather than fear. Uncertainty regarding specific transactions in personal circumstances warrants clarification before initiating fund movements. Questions deserve answers. Written confirmation provides protection. Personal notations establish records. Minor administrative measures undertaken today can prevent substantial stress in subsequent periods. Headlines may proclaim that $10,000 deposits position individuals on Canada Revenue Agency radar. Reality presents a more balanced picture. The deposit establishes a record within financial systems. What genuinely matters involves whether that record aligns with reported income and whether adequate explanations exist. When alignment occurs and proper documentation exists, fear typically proves unwarranted. Remaining informed, maintaining organization, and basing financial decisions upon factual information rather than panic constitutes the pathway to protecting retirement security in 2026 and throughout the years that follow.